Fox News senior judicial analyst Judge Andrew Napolitano is with us, as is the criminal defense attorney Randy Zellin. Judge, did you see the Sandusky interview with Bob Costas on NBC?
I did.
If his defense attorney saw that, my guess is they might hesitate to have him testify.
Well, Costas, who's a great TV guy, but is not a prosecutor, demolished Jerry just in the questions that he put to him, and that would be a very good indicator of just a very small percentage of what would happen to him on the witness stand. On the other hand, all of that horrific, absolutely unforgettable, vividly detailed, violent evidence of violence against him is unrebutted, is unchallenged, and therefore will produce a very, very quick, I think, guilty verdict. So this is what is being weighed in the lawyers' minds and in Sandusky's mind as they decide probably tonight whether or not to put him on the stand tomorrow.
The prosecution rested on Thursday of last week. They took Friday off, or maybe they went a little bit on Friday. At any rate, the defense began today. The defense will finish by Wednesday, according to the judge, with closings by the lawyers for both sides on Thursday. What's the defense trying to accomplish in the interim there, specifically?
Well, let's take one step back, because that schedule is a fluid schedule and can always change.
Sure.
But here's the critical thing. Your Honor, you aptly note all of the vivid, the graphic, the horrific. There's only one problem. It's not corroborated. Where is the janitor who saw this? He didn't testify. Where is the underwear? No underwear. Where is the child victim? The mother. At some level, you have to give a jury credit. We saw it in the John Edwards case where they said, wait a minute, he didn't get the money. Don't be surprised if you have one juror thinking the same thing. Horrific allegations, I need evidence.
Judge, if there is a plan now for civil suits, the subpoena was just issued, would that be admissible for these proceedings? Could the jury know, well, they're trying to make money off this?
Yes. Some judges will permit that in because it does undermine the credibility of those who are complaining. Not the fact that they're suing, because they have the right to sue. There would have to be something more there. There would have to be some corroboration, some collaboration, excuse me, some tailoring of testimony in order to enhance the civil suit. The existence of the civil suit itself doesn't damage in my view, doesn't damage the testimony at all.
Well, we know that authorities at Penn State and with the NCAA and with college boards are waiting until this is over with, before the Sandusky trial is over with, before they decide what to do, if anything, about Penn State and its institutional control.
Well, Penn State's going to pay out a lot of money. It's going to do it right away. It's going to do it for humanitarian reasons. It doesn't want these kids to have to testify, and it's going to do it for its own selfish reasons. It wants to turn the page and move to the next phase of its history. It doesn't want this thing hanging around any longer than it has to be.
Yeah, I'm sure it doesn't. Too long already for its purposes. Randy, Judge, thanks. A Texas teacher is out of a job this afternoon after she ordered her kindergarten students to line up and hit a fellow classmate, another kindergartner. She claims she was trying to teach the 6-year-old child a lesson for supposedly being a bully. According to the police report, the teacher told the other kids, quote, hit him harder. Another teacher involved is on paid administrative leave, but the parents of the kid want criminal charges. Let's get back to the legal panel. The criminal defense attorney, Randy Zellin, is with us, and Fox News legal analyst and senior judicial analyst, Judge Andrew Napolitano. Line up, boys and girls. Let's hit this 6-year-old so he learns better.
Well, if the facts are as we believe them to be, I don't even think it's a close call. This is criminal behavior on the part of the teacher. Corporal punishment is prohibited directly or indirectly. The harm visited upon the so-called bully and the harm visited upon the students who did the administration of the punishment is very, very serious.
Randy?
No crime. If a 6-year-old can't form the criminal intent to commit assault, meaning I have the intention to hit you to hurt you, if the child can't form the intent, then the adult can neither be an aider nor an abetter, which is a fancy way of saying I'm helping you to do it.
Okay, now wait. Now, under this theory, I could give a gun to my 6-year-old son, tell him to pull the trigger and kill somebody. Neither he is guilty, nor am I.
It's a very, very interesting question.
No,
but here you would have...
Of course I'm guilty.
No, because...
That's silly.
Of endangering the welfare, because clearly there your intent was to injure the child. Here there's no endangering because the teacher was trying to teach the bully a lesson. I suggest he bettered or she bettered the bully, didn't hurt the bully. the bully learned something.
I don't think Randy really believes that, so Judge, go ahead.
Randy makes great arguments, and one of the mark of a great trialer is you don't know what he honestly believes. But clearly, when you have legal authority over the children, as a school teacher does, you cannot use them for the purpose of inflicting violence, no matter the beneficial goal that might come from that violence.
Here, little
That
Johnny,
teacher,
go hand little Janie a cup full of cyanide. Here, have her try it. I didn't do anything wrong.
That teacher's gone and will be prosecuted and should be.
What do you think of this?
I
Johnny?
think it's absolutely nuts that any teacher would even think that this was a good idea.
Well, that is sort of a... That's sort of an absolute, isn't it? It is kind of nuts, isn't it?
It's kind of nuts.
Well, but you said it might better the child, so I was just curious if you'd change your
It
mind.
is kind of nuts. It's a creative way to better the child. I just don't think it's a crime.
Creative?
Yes, it's creative. It's creative.
Dyfus would be all over you like glasses on Zelen. So what do you think happens here?
Well, you know, sometimes these things are resolved amicably. The teacher will resign and lose pension rights and lose tenure, and it'll be over with. Or, depending upon how aggressive prosecutors want to get, they'll actually prosecute her, and a jury will have to hear the case, and Randy will get admitted to practice law in Texas so that he can defend her.
Hit him harder.
Leave it at an administrative level, and if for no other reason, why put the kids through more? Because in a criminal prosecution, they'd have to testify. Look what's happening in the Sandusky case.
Right. All right, Randy, Judge, Jonathan. The U.S. Supreme Court set to reveal its decision on President Obama's health care overhaul law. It's one of the High Court's most anticipated rulings in recent years, the outcome of which would affect many of us. Some were expecting a ruling today. It didn't happen. Next round of discussions due out Thursday. There's been speculation the court might extend its session to give the justices more time. Back to Judge Napolitano. Thursday, then Monday, and that would be the end of June. They'd said they were going to do this in June, so they could extend it.
I believe that the justices have personal and professional commitments which start at the end of next week. So we're talking about Thursday, next Monday, and then next Thursday is the absolute last date. But let me suggest to you what might be going on now. Justice Ginsburg gave a little bit of a hint of this over the weekend when she said, you will see in the remaining decisions just how divided the court can be. She said that with a lament. That tells us there's going to be a lot of dissents. On the Affordable Health Care Act, this could be one of the most profound decisions in modern times, or it could be a dud, depending upon what it says, what guidelines it gives us, and how it affects the future. But most of the justices will want to weigh in on it. So the majority writes its opinion, then the minority writes the dissent, then the majority gets to reply to the dissent. And then it gets a little dicey about who's going to go back and forth when. They're in that collegial process now. The majority speaks first and speaks last. Each of the dissenters wants to weigh in. And they're lawyers, Shep. They do everything the last minute.
They certainly do. So maybe Thursday, maybe the next Monday. We'll know soon enough. Judge, thanks.
Pleasure.
President Obama bypassing Congress with his new immigration policy, but questions remain over his executive order overreach. And what could it mean down the road for deportations and the courts? Joining us right now, Fox News senior judicial analyst Judge Andrew Napolitano. So, Judge, we got a new fly in the ointment. All this criteria now have to go in to the process, which is already backlogged with other illegals that are having their case seen.
Look, the problem is this. The president has unilaterally changed the law. He has rewritten the law. His heart may be in the right place for a group of people that he feels ought to stay here, but he can't do that. Only Congress can change the law. The law requires predictability, it requires fairness, and it has to be constitutional. If the president writes it, it's not constitutional. And if he changes the law, there's no predictability. And only the Congress can decide whether coming before age 16 is fair. How about 15? How about 17? The president just made these numbers up out of his own head, and we don't have a system that permits that.
So, Judge, let's talk about the court system around the country. What's this going to do for that process, which is already backlogged big time?
Well, it's going to make it difficult for the courts to know what the law will be. If Mitt Romney is elected president, will this new law that the president has written still exist? Well, we don't know. I think you'll have an interview with Governor Romney later today. Perhaps you'll ask him this. The point is this. If the president thinks a law is unconstitutional, he cannot enforce. He can refuse to enforce it. Thomas Jefferson did that. But the president cannot rewrite a law to make it more to his liking. Only the Congress can remedy that. President's bypassing the Congress yet again for what seems to be the umpteenth time.
You know what I would look at, by the way, I don't know who this Jefferson guy is. Remind me to Google him.
I knew him. I keep forgetting
I
that.
understand. You refer to him a lot. He wrote with that nice inkwell. But I got to ask you, I picture the courts, and I picture the backlog that's already there for illegals that could have their citizenship questioned. This is an administration that deports 1,150 per day, yet it's still backlogged. Now what is it going to do for those people that qualify, been here 5 years, served in the military?
Some of the people that are on line to be deported will be taken out of that line because they will fit the president's qualifications. But the point of the Constitution is only the Congress can write the qualifications. Suppose the Supreme Court upholds Arizona's law later this week or early next week. What law will Arizona enforce? The law the Congress has written? The law the president has rewritten? Will Arizona arrest illegals only to find out that the federal government refuses to deport them? And what will it do with these people after they've been arrested for being here illegally, but the government won't allow them to be deported? It's a mess that he has created, and he's violated the Constitution in doing so.
And for all practical matters, the approach and the objective of this is to win over the Hispanic community, and we'll see if that'll be effective.
Gee, do you think that has anything to do with the presidential election coming up?
I think we're getting a little cynical. Sadly, we don't have any more time. Judge Andrew Napolitano, always great to see you. Thanks so much.
Pleasure. Is it really great to see me?
Yes, it is great to see you. Absolutely.
Pleasure.
In person.
Pleasure,
I
Brian.
see your picture everywhere.
We are awaiting two big decisions from the Supreme Court, which could come any day now. One on President Obama's health care reform law, specifically the law's individual mandate. The other decision on a challenge to Arizona's immigration law, which would require anyone stopped by police to prove their immigration status, that they are here in this country or in Arizona legally. Joining us now for his take, Fox News senior judicial analyst, Judge Andrew Napolitano. Judge, you have said for a long time you think this Supreme Court is going to strike down Obamacare. Why?
Well, I have said it because it directly extends the power of the Congress beyond anything contemplated by the Constitution, if the Congress can force you to buy a product. That's been reinforced by the questions that were asked by the justices at the time of oral argument. I mean, we'll know very soon. Either this will be a monumental decision that will restrain the Congress from interfering in the personal lives of individuals, or it will be a dud. And we'll basically say Congress can write any law that it wants, regulate any behavior it wants, tax any event that it wants, and call it a fine or call it a tax, depending upon how it wants. I expect the court to restrain the Congress and to set down guidelines once and for all about just how far Congress can go under the Commerce Clause and how far it can't.
But if Congress can tell a farmer under the Commerce Clause that he can't plant wheat on his farm, can't it tell you to buy broccoli?
You know, that's a very, very interesting question. You are speaking of a case called Wickard against Filburn, a 1942 Supreme Court case. This past weekend, Justice Scalia, inadvertently or intentionally, released to the public the manuscript of his next book. In that manuscript, he says, this is one of the worst cases in history, and it ought to be reversed. Is he telling us something that might happen in the next 10 days?
Interesting.
One doesn't know, but one can only speculate.
Now, what about the Arizona law? The Supreme Court has been taking up that law, which the Arizona legislature passed, saying that Arizona law enforcement officers are required to check the immigration status of people they pulled over for violation.
Well, the president has added a very complicated gloss to that by the decision that he announced last Friday when he, on his own, rewrote immigration regulations to say that if you came here before you're 16 and you're under 30 and you're still here and you came because of your parents and you didn't break the law and you went to high school and graduated or you were in the military, a bunch of regulations that he put in there, you can't be deported. So if the Supreme Court upholds the Arizona law, and if Arizona decides to enforce federal law where the federal government is not, which federal law will they enforce? The laws written by the Congress or the laws rewritten by the president? This will become enormously complex. What will the court do? The oral argument, again, the questions by the justices seem to indicate that they were favorable towards that Arizona statute. But again, we'll find out in a couple of days, maybe as soon as Thursday.
We might find out on television because a couple of senators have written a letter to the Supreme Court. Here's how it reads in part. They want cameras in the courtroom for the big health care announcement. Senators Leahy and Grassley write, broadcasting the court's ruling would permit millions of citizens the opportunity to view what so few can from the court's small and limited public gallery. Modern technology makes televising the proceedings simple and unobtrusive. A minimal number of cameras in the courtroom, which could be placed to be barely noticeable to all participants, would provide live coverage of what may be one of the most historic rulings of our time. We believe permitting the nation to watch the proceedings would bolster public confidence in our judicial system and in the decisions of the court. Will they go for it?
No, they didn't go for it during the oral argument of Bush against Gore. They're not going to go for it now. But my hat is off to Senators Leahy and Grassley. They've been pushing for this for a long time. I don't think it's going to happen for a long time.
Judge Andrew Napolitano, always good to get your legal take.
Pleasure, John.
Thank you.
Thank you.
Back to our breaking news. Elijah Cummings now at the microphone there. This is what Darrell Issa stated regarding executive privilege only moments ago.
Over and over again, the department has sought to protect its political appointees. It has used this investigation by its investigation by the department's Inspector General, which has been pending a very long time, as a reason not to cooperate. We are now on the second Inspector General. There's been no interim report, and although they say it will be forthcoming within a month, we and the American people need answers sooner, not later.
But apparently those answers will not be today, and possibly not anytime soon. Judge Andrew Napolitano with me now. Judge, good morning to you. Executive privilege now exerted, signed off by the President. What does this mean, Judge?
This means that this is going to a new level this morning, Bill. This means that we may be on the precipice of a constitutional confrontation between the executive branch, the White House, and the Congress. Executive privilege is defined in the leading Supreme Court case, interestingly, United States versus Nixon. That's Richard Nixon. That's the Watergate era. That's the efforts of the special prosecutor to subpoena tapes from President Nixon as protecting conversations with the president himself. Now, the letter that Eric Holder wrote to the president saying, please give me executive privilege, does not say, because I discussed this with you, Mr. President, but the implication is there. Executive privilege protects communications with the president, the human being of the president, not with people that work for him and the Justice Department.
So let's be clear now. You say this is not an acceptable subject for executive privilege.
Correct. Unless
then why would they seek this?
There must be something in these documents, or there must be someone who observed these documents that the Attorney General is trying to keep from public view. If the Attorney General sat down and discussed it with the President, he probably doesn't want the Congress and the public to know that, because we know of the awful events that occurred as a result of the Fast and Furious escapade. But we also know that executive privilege only pertains to military, diplomatic, and sensitive national security matters. Now, was fighting the drug gangs at the border a sensitive national security matter? And if so, was the President of the United States of America personally involved in making decisions as to how to conduct that fight? If that's the case, this has reached a different level, and we now know why the Attorney General has ferociously defended these documents and refused to reveal them.
Two specific questions. Does the Attorney General now have to show or prove why executive privilege applies here then?
Well, the Attorney General is arguing that the committee has to show why executive privilege does not apply. The last time this happened, 40 years ago, in the Nixon-Watergate saga, a federal district court judge got involved, and he ruled against the president, and the Supreme Court upheld his ruling. We may be seeing this going in that direction now if there's a standoff between the president and the Congress, the Attorney General and the Congress, the court. The courts will resolve that standoff.
Okay, now back to the comment you made 2 answers prior. If the Attorney General had a conversation about this ATF operation in Phoenix, Arizona with the President of the United States, perhaps executive privilege applies here. But what would the President of the United States have to do with this operation run by the ATF allegedly out of Phoenix?
Well, I could only speculate. I have no basis for this, but the President of the United States may have wanted to participate in decisions about defending the border between Mexico and Texas, Mexico and New Mexico, Mexico and Arizona, and they may have run this past the President. But, Bill, If the President of the United States knew about this, if Attorney General Holder discussed this with President Obama, that would be at odds with his testimony under oath given to Congressman Iss's committee, and then he'd be in a lot of hot water. He'd be in the situation that he claimed Roger Clemens was in when he misled the Congress.
David Schweiker, congressman from Arizona, was with Martha just a few moments ago.
Right.
He said, makes you wonder what they don't want us to see.
Congressman Schweikert is correct. It does make you wonder what they don't want us to see. See, they can't have it both ways. If the president was not personally involved, executive privilege doesn't apply. If the president was personally involved and they want to argue that, that fighting drug gangs at the border is a matter of sensitive national security, then they at least have an argument for executive privilege, but that would be at odds with what Attorney General Holder has already testified to under oath.
All right, listen, don't go far. We need your knowledge. Thank you, Judge.
All right, we've already told you that the Attorney General of the United States is being held in contempt along pretty much party line vote. The House Oversight Committee has voted to hold him in contempt. That Speaker Boehner now throughout the House is looking for a vote sometime next week. They say this won't happen, though, if the Attorney General hands over some documents. So we've got a bit of a potential constitutional crisis brewing. And whenever I use constitutional and/or crisis, I think the judge. Napolitano, where's this going, Judge?
Well, the president just raised the heat on this, Neil, by invoking executive privilege. Let me restate that. By the Attorney General asking him to invoke executive privilege. The president needs to invoke it himself in a document he signs, and he needs to say why he's invoking it. He can't invoke it for any reason he wants. It's got to be a reason consistent with law, which means a military secret, a diplomatic secret, or a national security secret. Flip side of this is the irritation on the part of members of Congress, because the Attorney General actually had agreed to give the documents over, as to which he has since asked the president to claim executive privilege. So the vote today was just a vote of a committee, not to demean it by calling it just a committee, but it is not a vote to hold him in contempt. It is technically a recommendation to the entire House that he be held in contempt.
What if the entire House or a majority in this Republican House holds him in contempt? Then what?
Well, we have a very, very complex situation on our hands, because this is what's called criminal contempt, meaning he would need to be prosecuted for it by a federal prosecutor in a federal court. And he himself, of course, is the chief of all the federal prosecutors. So the leadership in the House would then either have to hire a lawyer or persuade a federal prosecutor to seek the indictment of the Attorney General for contempt of court. If he is indicted, then he would actually be tried before a judge and a jury in a federal courthouse, the same courthouse where Roger Clemens was just tried, where his team just prosecuted Roger Clemens. He theoretically would be a defendant in that courthouse in this criminal prosecution for contempt.
Now, they can battle over what type of documents they want. The House seems to want everything, right?
Yes.
And I guess the Attorney General has said, I'll give you synopses or something like that, or the cursory reports, not the real dive into the detailed stuff. I mean, what will satisfy, do you think, John Boehner, Republicans, and some of these others, or does this get full-blown? They get every little detail, every little correspondence, every little email, or there's hell to pay?
Well, look, if he's held in contempt and if he's sentenced to jail for contempt, those are two big ifs. This has not happened in modern times. He would be incarcerated for this. The theory being he violated a specific and lawful command, a subpoena from the Congress. This is not the kind of incarceration that our colleague Judith Miller went through, where they kept her in jail until she coughed up the documents. Eventually she didn't. The prosecutor got the documents by another means. So we don't know how this will end.
All right, Judge, thank you very much.
All right, let's talk a little bit about what happened yesterday in Congress. You probably
What
saw
didn't
it.
happen yesterday?
Man, what a blockbuster of a day. The House Oversight Committee approved a resolution on a party line vote of 23-17, holding Attorney General Eric Holder in contempt of Congress. This was a resolution. It now moves on to the full Congress for a vote next week. However, according to Mr. Issa, Mr. Holder right there would not be brought up on the contempt of Congress charges charges if he produces the papers, the documents that they want to see regarding Fast and Furious.
And on top of that, the reason why he's not going to produce it, because the President of the United States factored himself into this, because he says, I will shield those papers from going out. I'm going to exercise for the first time in my 3.5 years executive privilege. Therefore, we're going to keep the papers here. However, for the first time, you're thinking to yourself, what does the president have to do with this?
Yeah.
You know, why would he use this time at this point, after in the 11th hour in this investigation, to say, I don't want you reading this. I think I need to stop it.
And of course, there are those who say that this shouldn't be about politics. This should be about finding out what really happened. Among those is Brian Terry's mom, who spoke on radio.
My son was a person that believed in justice, and he believed in telling the truth. He was a man of his honor, and if anybody knew him, they knew that. And I know he would be saying, you know what? I died for my country, and he was a true American, and I think he deserves the truth, and I think everybody should know the truth. And if this was a bad thing that they did with Fast and Furious, it should be acknowledged so it never happens to anybody else's son.
That poor family just wants to get to the bottom of the story, and now the president has inserted himself into it by claiming executive privilege. Why did he do that? Here's Congressman Gowdy yesterday.
If he did not know about Fast and Furious before Brian Terry was murdered, if he did not approve of the wiretap applications, then what in the world is he asserting executive privilege for? He's either part of it or he's not. If he's part of it, then we've had a series of witnesses that have misled this committee. And if he's not part of it, then he's got no business asserting executive privilege.
Let's bring in Fox News senior judicial analyst Judge Andrew Napolitano. Judge, are you shocked this happened, or were you expecting it?
No, I think we were all shocked that it was happening. Brian, as recently as 3 or 4 days ago, the Attorney General was offering to reveal the very same documents as to which he has now asked the president to claim executive privilege. This is a very rare thing, executive privilege. It basically permits the president to hide the truth from the courts or from the Congress, because it's the type of information he needs to have. So if, for example, Valerie Jarrett, just a hypothetical, and Eric Holder have a conversation in the White House about the Yankees and a conversation about Fast and Furious, neither conversation is automatically protected by executive privilege, because the conversation, in order to be protected, must be intended to advise and inform the president about his official duties, so the Yankees would be out, and it must be in the areas of military secrets, diplomatic secrets, or sensitive national security. Can you even think of how gun running to Mexican gangs, which resulted in the murder of an American federal agent, could fit into any of those three categories?
Try to figure out how for us.
That's the problem that the president had by saying, I'm going to claim executive privilege. He now, in order to claim it, must explain it in a writing that he signs. He must justify under the law.
When is that coming?
That would have to come very soon, in the next couple of days, Brian. Otherwise, there would be no executive privilege, and the Attorney General would be compelled to reply under pain of contempt.
This could be a stalling tactic, though. I mean, there is still time to turn over the documents, or does the president necessarily have to explain himself? There's
the president
another way
will
out.
have to explain himself before the privilege is invoked, and then if the Congress wants to, they can challenge the privilege before the courts. President Bush did this, and he lost 6 challenges when federal judges reviewed the documents he tried to keep from the Congress, and the judges ordered him to reveal them.
I mean, Washington even tried to do this thing, and he got stopped from doing that.
A lot of presidents lose this, but this one is suspicious because it comes so late in the game, and because, as I said, it pertains to documents they once offered to reveal.
2 days earlier, you want to see him. 2 days later, it's like it's a big secret. Now the question comes down to, you know, who's the Attorney General working for? Is he working for the President of the United States exclusively, or for the people of the United States? Here's Barack Obama in 2005. Listen to what he had to say back then.
The President is not the Attorney General's client. The people are. And so the true test of an Attorney General nominee is whether that person is ready to put the Constitution of the people before the political agenda of the President.
Well, at the time he said that, he was saying a correct statement. The Attorney General's client is the federal government and the people. It is not the president. The president has his own lawyer. He has his own team of lawyers in the White House.
We were looking at a scorecard a minute ago of presidents who have used this in the past. Of course, President Clinton used it the most 14 times, executive privilege. How does it usually turn out? Are they usually able to defend it well?
Sometimes the Congress backs down,
as they did when President Bush invoked it for Harriet Miers and Karl Rove. Sometimes the Congress challenges the president in court, as they did several times with President Bush, and sometimes the Congress wins.
And real quick, the Fast and Furious investigation is about dumping about 2,000 guns into Mexico. Evidently, hundreds of Mexicans have died using our guns. It's mysterious why American guns would be needed in Mexico when they can get them dumped on the street without going through the paying the high price and using our guns and taking that risk. However, having said all that, Eric Holder in particular has proven some statements to be fallacious. Along this way, he's testified, he's given over paperwork, but a lot of stuff, including his accusations against Michael Mukasey, has proven wrong.
He has actually retracted statements. The Justice Department has retracted information it has given to the committee. That's why Congressman Gowdy was so furious. They don't know if the Attorney General or if the Justice Department, which is charged with enforcing federal laws, is telling the truth to the Congress.
All right. Judge Andrew Napolitano, you can get more of his opinion regarding this and so much more at foxnews.com/opinion.
Thank you, guys.
Thank you very much.
Let's take this to the judge, why don't we? Fox News senior judicial analyst Judge Andrew Napolitano is on set now. Judge, is this just all politics, or is there more to it?
No, there's actually a constitutional clash here, and the Supreme Court resolved it in a very famous case called United States versus Nixon, which the president's documents had been subpoenaed, and he refused to comply with the subpoena. So the first question is, were the conversations about the documents intended to advise the president on his duties as president? I mean, if they're talking about the Yankees, that's not going to be covered by executive privilege. But if they're talking about something that they intend to use to formulate advice to the president, it could be covered. The second inquiry is this advice about a military secret, a diplomatic secret, or a sensitive national security secret? Those are the only three categories of permissible executive privilege. If it doesn't fall into one of those three categories, and admittedly it's difficult to find how this gun running thing could be military, diplomatic, or national security, then the privilege doesn't apply. Think about it. A privilege is the right of the president to keep the truth from the courts or from the Congress. And Congress has the right to look for the truth, and the courts have the right to look for the truth. So the circumstances under which you can stop the truth from moving forward are understandably narrow.
We've made it clear here before, and it's worth reiterating, presidents do this. The last one did it, the one before that, the one before that. Well, this is the first time this one's done it.
President Bush did it 6 times, and 4 of those were overturned by judges who said, let me hear the testimony in secret, let me look at the documents in secret, and I'll decide if the privilege applies. 4 times the judge decided they didn't apply. That might happen here. It won't happen before Election Day, which is probably what the Republicans would prefer, but if they continue to push this, if the president is reelected, it could be addressed a year from now.
But then under any and all circumstances, it would go before a U.S. judge.
Go before a federal judge in Washington, D.C., just as did the challenges to President George W. Bush's assertion of the privilege.
But this matter of holding him in contempt, it doesn't end with the House. We then have to go to the judicial branch.
Now you're talking about, yes, correct, Shep. Now you're talking about a different matter. The House would have to vote, the full House, not just this committee, to hold him in contempt. And then a federal prosecutor, and Eric Holder is the chief of the federal prosecutors, a federal prosecutor would have to seek an indictment, get an indictment, and prosecute him in the same courthouse in which Roger Clemens was just prosecuted for contempt.
We shall see. Judge, thanks so much.